Welcome back to the Oxendine Law podcast. Jarrod Oxendine, your host. Christine Palmer, your co-host. You've all heard it. You've all dreaded it. You know somebody who's been through it. Maybe you're going through it right now. It's the dreaded custody battle. We're going to give you tips and pointers today on how to effectively and properly present your case, prepare for your case, and what to do after your custody determination has been made. So let's dive right in and talk about contested custody battles. Those can be long. They can be protracted. They can get expensive. They can get ugly. They can get nasty. They don't always have to. But let's assume you're in one of those nasty, ugly custody situations. You can't settle your case with the mom or the dad, and you end up having to go through a contested custody battle that actually involves a hearing process, the full 9 yards. Christine, how do we first get that process started? What are some of the first things we want to do to start getting prepared to walk in the door of the courtroom and win a contested custody battle?
Sure. So first, I want to touch on why are these custody cases such a battle? And a lot of times it's because one parent thinks that they're a better parent than the other or something. Those are the ones that I dislike because I feel like they're really brought with emotion and judgment. And sometimes they're right. Sometimes one parent is clearly superior in their actual parenting skills than the other parent. But the ones that are always interesting are ones that deal with things like proximity, right? So we can't do a 50-50. And so since when there can't be a 50-50, each parent thinks they should be the one. So it doesn't necessarily always mean that you've got one parent that's like a drunk or that one parent has done something completely wrong. Like that's not usually our heaviest custody battles. It's when both parents are excellent parents. Both parents are really, really good at what they do. So there isn't a clear winner.
And they're both adamant that they should get custody.
Yeah.
We do have those cases, though, where it seems very clear to us that one party's superior, but the other party's just difficult.
Yeah.
And for whatever reason, whatever their motive, maybe they don't want to pay child support.
Right.
Maybe they just want to keep that control over their ex-spouse or the other parent.
Yeah.
And so they ask for custody when they really shouldn't. Doesn't really matter what the motivations are. If you're in that situation, you still got to go through the process and jump through the hoops.
That's right.
So how do we start getting clients prepared to walk in the door of that courthouse and win their custody battle? I'll get started. First thing we need to do is make sure we've got all the evidence that we possibly can to possibly help support your case, all right? I'm talking text messages, emails. We're talking about surveillance videos, audio recordings. Have your witnesses ready and lined up to go. You know, one of the good things about custody hearings is if it's a temporary, you can't do this on a final, but if it's a temporary, you can actually get your witnesses to complete affidavits.
Right.
And we just file those with the court. And it's just like that witness came and testified in court, but they're not subject to cross-examination and they don't have to show up in court. You can only do that for a temporary, but you got to have those affidavits ready to go. And in certain cases, it may be that we need a guardian ad litem appointed before we walk into the door and have our custody battle. Christine, why would it make sense before you have your custody hearing in certain cases, not all cases, because some cases we don't need a guardian, but when would a guardian be needed before you walk in? Because you get one bite at the apple, right? You walk in and you blow your load to speak, that's done. You can't come in and change a judge's mind unless you've got something drastically different. So are there situations where you might want to get a guardian appointed to investigate before you walk in the door and have your custody battle?
100%. A lot of times the guardian is going to be helpful when you've got a true he said, she said. So your client is saying one thing, another client is saying another, but there's not evidentiary proof. So like Jarrod just said, the first thing we're going to ask you is, okay, I hear your allegations. Where's your proof? Where's your evidence? Not because we second guess you, because that's how I'm going to prove it to a judge later. So if you tell me that he is extremely narcissistic and abusive and he's just gaslighting and blah, 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 but you don't really have proof, quote unquote, proof of it, I can go tell that to a judge and you can tell it to a judge and he's going to sit on the stand and say, I have no idea what she's talking about. She seems a bit emotional right now, blah, 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 right? He's going to play the role. If you get a guardian, that guardian, it's their job to immerse themselves in the child's life. They're not picking mom's side or dad's side. They're saying, what does my client, who is the child, go through every day? And they're going to talk to the child, no matter the age. They're going to have a one-on-one conversation, age appropriate, and they're very well trained. Conversation with the child, and they're going to get the inside scoop from the child. So number one, it's going to prevent the child from needing to testify in court. There are very limited circumstances where that's still appropriate to have an older child testify to a judge, sometimes even slightly younger in chambers. But those are very extreme circumstances. Generally, we're going to have them talk through a guardian.
I'm with you. I mean, that's when I ask for a guardian is either I've got an uphill battle because sometimes the facts are not always on my client's side as much as I'd like them to be. And sometimes if you can get a guardian involved, it can flip the script. Because if you can convince the guardian to go your way, judges almost always, with exceptions, but for the most part, they're going to rely heavily on the guardian's opinion. So I do it in that circumstance. Or if my case is based mostly on hearsay, so it's based on what the child is saying
Yep.
or what other people are saying, because the guardian can get out there and do things the judge can't do.
Right.
And frankly, the things we can't do.
Sure.
They can go meet with all your witnesses. They can go interview the child. They can go meet with the teachers and the doctors and just do all the legwork stuff, visit both parents' homes, and basically make a report back to the court and to the attorneys about what they found and what the recommendation is and why. So there are circumstances where you might want to invest the time and the money in getting a guardian ad litem appointed before you ever walk through the door of a courthouse. But if it's not a case where you need a guardian, then that tells me you have come to us and you've got really strong, compelling evidence in support of a really good claim for custody. And when I get those fact patterns, I get in quickly. In my opinion, there's only one way to win a custody case, and that's to be very aggressive with it. You've got to put pressure on the other side. You've got to move it quickly. You've got to get into court as fast as you possibly can, which means you've got to get all that legwork out of the way. We got our witnesses lined up. We got our evidence ready to go. We've got affidavits done if we need to have affidavits done. If we needed to get surveillance done, a private investigation done, whatever it is, we get all that done. And then we file the case and we get the quickest court date and we go in and we sling it out. And sometimes you'd be surprised when you're that prepared and ready to go and you've got good reputable counsel. Sometimes those cases settle before you even walk inside the courthouse steps.
Sure, because and again, it goes back to why is this custody battle so contested? We've both had the cases where one parent is just digging in their heels for whatever reason, and they're not going to move, and they're not going to compromise, or they have maybe not the best representation, and their counsel is not giving them good advice, saying, look, looking at this objectively, I don't know that a judge is going to agree with you. That's probably some of the hardest conversations you ever have, right?
Sure.
Is with a client when you're saying, I hear you, and I'm not saying that you're wrong, but I'm telling you that I know how to look at this objectively. And while you are an amazing parent, legally, that parent has the better capabilities to be the primary parent. It doesn't make them a better parent. I'm not saying they love their kids more than you do. I'm not saying that the children love them more than they love you. What I'm telling you is courts look at certain factors up to which parent is going to be the primary. And I will tell you the number. I've had multiple judges say it to my face, to my clients. You hear it at every CLE. The number one factor that a judge looks at in every single custody case is which parent is most likely to promote and support the relationship between the children and the other parent. If you've got one that's willing to do that and one that's throwing up roadblocks and obstacles and is difficult to communicate with, that parent is not on a good path for custody. And that's the ones that I struggle with when I have those as my client. And they're saying, well, look at this and look at this. And I'm saying, I understand, but you have to understand she's trying or he's trying and you're the one that's being difficult. And it's like, they let all the other factors come in. Well, she cheated. Okay, well, that has nothing to do with your custody right now. So really looking at why is it such a hard battle is the best way to plan for how do we attack it.
Well, and I'm glad you mentioned that. And folks, look, make sure you hire an attorney that's realistic with you, right? You don't want to hire an attorney that's just a yes person. I mean, they're doing you a disservice. They need to give you their honest opinion on whether you're being reasonable. And if you're being unreasonable, they need to let you know you're being unreasonable. The final decision is still yours. If you want to go in and have your contested custody hearing, even though your attorney has told you, hey, you don't really have the best chance at custody and you may get a better result if we can negotiate something outside of court. If you still want to go in and have your hearing, we'll do that all day long. But you've skipped a step if you have an attorney that has not at least advised you of your other possibilities. Again, keep in mind, once you try your case in front of the judge, whatever the judge decides, that's what you're stuck with. And there's been a lot of circumstances and scenarios where I felt my client didn't have the best chance at winning custody if we had the hearing. But the other side doesn't know that I've told my client that.
Sure.
They know we're ready. They know our reputation. They know we're fired up. And they know, based on having had cases with us before, that when we go to court, we're going to give them all they can handle.
Yeah.
And for that reason, I've been able to use our reputation and experience to actually negotiate an agreement outside of the custody battle that probably is a better outcome for the client if they went into court and didn't get custody, right? Because if the judge decides you're not getting custody, then the judge decides parenting time. Well, what if I can negotiate for you? It's not the label of custody, but on paper, you've got essentially half the parenting time.
Right.
And maybe you've got some final decision-making authority. Who cares about the label at that point? I can almost guarantee that if you go in and have your nasty, drag down, knockout, contested custody battle, the judge is probably not going to do anything close to 50-50 because the judge is going to say, y'all don't get along well enough to do 50-50, but I might can get you that result in a settlement. So
Right.
I love that you brought that up. Make sure you have considered and exhausted all your settlement options and you listen to your attorney's advice as to your prospects of actually winning the custody battle. And if your attorney, for the right reasons, is saying, this is not a slam dunk, I might can get you a better deal on parenting time, let's at least try to work the settlement. I think you're remiss if you don't at least try because there's no downside to that. If you don't work it out, you still go in and have your custody hearing.
That's right.
So I love that. All right, factors. You touched on it, Christine. Factors judges consider in determining custody. You touched on a couple of those. I would say, in my experience, probably the number one thing that judges look at first is who historically has been the primary caretaker. And just in my mind, that's what judges tend to look at first. Who historically has handled the day-to-day, who is responsible primarily for getting the children to their doctor's appointments and getting them to school and picking them up from school and getting them to their extracurricular activities and all the day-to-day stuff that goes into caretaking of a child. Wouldn't you say that's probably the first thing judges tend to look
Sure.
at?
I mean, of course it is. That we know that they're going to look at the history. And why that's not to favor that parent. That is because a judge's job is to make this divorce process as least impactful on that child as possible. If they're used to mom waking them up, making their breakfast, and putting them on the bus, the judge wants to see mom continue to wake them up, get them breakfast, and put them on the bus. It doesn't mean anything about judges decided mom's a better parent than dad. Vice versa. If it's dad who has a flexible schedule and he works from home and mom gets up and she leaves and he's the one that's getting him up, he's been the primary parent. So it really is about least disruptive for the child. So remember that. Remember when you're looking through a lens of a judge, because how many times has the client told you no reasonable person would hear this and say that he's a better parent than me? Okay, it didn't say anything about that. The judge has said, what have these children experienced or child experienced every day of their life? And how do I keep that as consistent as possible?
And the important point there, though, folks, is that that's a rebuttable presumption. Just because you've historically been the primary caretaker doesn't mean you're automatically guaranteed to get custody. That is a rebuttable presumption. We've all seen the cases where you've historically had somebody that's a primary caretaker, but they're not willing to co-parent.
Correct.
So they will not communicate with the other parent. They won't include them in decisions. They make decisions unilaterally without consulting with that parent. And then to take it a step further, maybe they're also denying that parent parenting time.
Yeah.
They're alienating that parent.
Yep,
They're talking negatively about that parent to the child.
Yes.
If you've got a parent that's historically been the primary caretaker, but they're doing all those things on top of it, now that's when you can flip the script.
Yeah.
And perhaps the parent that's not historically been the primary caretaker should get custody. It's all about, at the end of the day, what's in the best interest of the child or the children.
Right.
And that's the final decision the judge gets to make. So the judge is going to take into consideration historical roles and work schedule and where everybody lives and who's in the school district and who's not in the school district. Are the children going to have to change schools? Are they not? But at the end of the day, it all comes down to which parent are the children's best interests going to be best served to live with primarily.
Right. And usually that is some sort of equal sharing. It doesn't have to be exactly 50-50 to the day, but it is a heavy involvement from both parents in most cases. The ones where we see one parent get limited time is where they literally like you said, they can't cooperate. They can't co-parent and they're harming their children's interests because of the way they feel about the other parent. And they are letting their relationship with the other parent interfere with their relationship with the children. So if you can bring a case where you are showing a judge that everything you're asking for, all of your intent, all of your requested relief is truly because it's what you believe is in the best interest of the children, that's going to be your best possible result. It doesn't mean you're automatically going to win, but it shows the judge that your intentions are in the right place. It's not about taking time away from the other parent or some competition of, I need more time because I'm more important or I'm better or whatever. It's simply about my children will be best served because blank, and that's how you present your case. That's where you're most likely to get a good result.
Yeah, and your actions matter. I mean, you need to be able to walk in a court and show that you're reasonable, that you're level-headed, that you have been co-parenting. I mean, folks, be careful what you put in writing.
Yes.
I mean, be careful what you send out in text messages, emails, what you put out on social media. Judges hate it when you're talking negatively about the other parent on social media because people in the community can see that. Other parents can see that. Goodness gracious, other children that are friends with your children can see that. That doesn't help you get custody.
Right.
But if you can walk into court and you can show where you are constantly trying to maintain level-headed,
Yeah.
not emotional communication with other parent. Hey, I'm thinking about enrolling Johnny into soccer. But before I did that, I wanted to reach out and see what your thoughts are. That's the kind of stuff you got to have. Hey, I just found I was at the school today. This is not something that's publicly available, but the teacher told me about this surprise party that we're doing for one of the kids in the classroom. They've got a birthday on Friday, and all the parents are invited to attend. I just wanted to make sure you knew about that so you could attend if you want to. You got to do that kind of stuff, even if you're doing it just to dress up for court. I
Right.
mean, let's just be honest. But
Yeah.
judges want to see parents that are able to communicate effectively, openly, honestly, calmly.
Yeah.
And you know what's great evidence? You sent out that nice text or that nice email, and then the other party blasts you back. They email or text you back. They're cussing, they're yelling, you're awful,
Name
you're not,
calling.
and they're not at all trying to co-parent or address the reason for the original text or email in the first place. That's a custody killer
So
for
you
that
cool
person.
with soccer or no?
So I'm taking that as a no. I'll proceed with soccer.
Yeah. Well, I not only that, but and sometimes people think about it in regards to those organizations, school or an activity or whatever. It's also nice to just keep the parents generally apprised. Like, hey, so and so's got a loose tooth, or like ask him about it, or hey, ate a new food today and like tried sushi for the first time, really enjoyed it. Maybe y'all can do a sushi date in the future. Just those little things. Remember what it was like when you were a happy married couple, or at least semi-happy married couple, and you shared those things. You're only divorcing your spouse as a husband or wife. You are not divorcing them as a mother or father. So if you can just focus on improving that role, then the judge is going to appreciate that. And that's going to be the key to your custody battle. It truly is being the best parent you can be.
Well, and keep in mind, I mean, once you win your custody battle, that is not the end.
That's not.
Custody, parenting time, always subject to modification once the case is done. So you've got to continue to fulfill that role. You've got to co-parent. You got to communicate. You got to make decisions that are best for the kids. You can't be talking negatively about the other parent. You can't be withholding parenting time.
Right.
You start doing that stuff, the other side has the right to come in and file for modification. So that's why judges spend so much time in custody matters. They're really, if I was a judge, and I've heard judges say this, they would tell you the most difficult cases they deal with in family law cases with custody matters, because it is a big deal. It's involving your children. It's life-changing. It's permanent.
I mean, I'm a child of divorce. Like, I know what an impact it can make. Money's money, property's property, debt is debt. You can get out of that. But it's not just about what it impacts the two parties. Like, you're a judge and you've got two adults sitting in front of you. And those people have chosen to be married and to no longer be married. So those are choices they've made, and they're dealing with those consequences. But who didn't make those choices is the children. And so you are a judge thinking, I've heard this case for 5 hours. I know maybe a dozen things to be true because I've got he said, she said, truth somewhere in the middle. I know a few things that I think are certain. And now I've got a 5 and 7-year-old sitting here, and I'm going to make a decision that's impacting the rest of their lives and how they're going to be married one day and how they're going to treat their children. It's a generational impact when I decide where these children sleep every night. That's a heavy burden.
And judges, I will say, judges really do try their best in custody cases.
They do. Yeah.
So you find yourself in a contested custody battle. Some are legitimate, some aren't. We've highlighted some of the legitimate cases where both parties actually have a good claim for custody. They legitimately both have demanded their day in court, which is great, and they've had their day in court and the judge makes a decision. But you may be somebody who's in a situation, and it's one of those examples we talked about earlier where there really should be a clear winner, but the other side's just being difficult, just to be difficult for whatever reason. You know what? Go in, kick their butt, have your contested custody hearing, win custody, ask for attorney's fees, because that's the punishment for that person. If the judge ends up deciding against them and you can show that before you went to court, you made reasonable offers of settlement, you offered them something very similar to what the judge finally ended up
Usually
deciding.
better
They
than what the
lose.
judge decided.
Yeah, even better sometimes. And they lose. They've caused you to have to incur all this additional money and time and attorney's fees. You absolutely have the right to ask for that party to pay all or at least some of your attorney's fees. And if the judge finds that their case was that frivolous, my experience has been the judge will usually award that.
Especially related to custody, because the judges actually expect you to, as parents, to make that decision on your own. You'll hear judges say it all the time. If you're bringing this case to me, either one of y'all is being ridiculous or you both are. And they kind of have that mindset starting off, right? You obviously know better than I do what's best for these kids. So the fact that each of you are coming to me to make this decision, I got to determine, is it one of y'all's fault or is it both of y'all's fault?
Thanks for joining us on this episode. Custody battles can be very complex. They can be challenging, but with the right preparation and the right advocacy, you can go in and kick butt and win your custody battle. Be sure to follow us. We're on all major social media platforms. Again, if you're following us on YouTube, hit subscribe. We look forward to seeing you on the next episode.